Swayam Prabha. Digital India. Educated India.
Dear students, the last part of this particular course, and we are happy to offer this particular course, and there was with a lot of objectives, because in India the IPN competition law is a new area, a new branch of law and economics, which came into the play very recently through a number of cases, came before the Competition Commission and other relevant authorities. So, the main objective of this course was to know about the interface between, our focus of our course was on the intellectual property versus competition law. So, what is the different categories? So, in the beginning, if you can look into the first part of our course, it was Introduction to Intellectual Property Law, which contains all the 7 categories of intellectual property law, starting from patents, trademarks, copyright, and then geographical indications, integrated circuits, and undisclosed information, and also the designs. So, all 7 categories of intellectual property law explained in the first part, and in the second part we discussed about the introduction to competition law, and within the competition law we try to understand what are the 2 major domains of competition law, that is the abuse of dominance and anti-competitive practices. And after this particular module, which barely gives bare minimum of understanding of this competition law, and we move to competition law versus intellectual property law, that was the core of our course. The core discussion of our course was on competition law and intellectual property law, and we discussed the concepts, the different concepts of intellectual property law as well as the competition law. So, simply we can see that the interaction between intellectual property and competition law, the border line is very thin, and intellectual property law gives monopoly rights for a minimum period of time. At the same time, the competition law never prohibits monopolization, but it prohibits the abuse of monopolization. And you can see the different categories of the competition law branches and the different prohibitions, like in the areas of time, cartelization and monopolization, and the geographical distribution of markets, and so forth, and how these intellectual property protection interfaces with the competition law, how the technology areas, for example, in the United States as well as in European Union, the Microsoft was heavily fined. The Microsoft was a major the software company, software not only software company, because of the we can say that technology company which was fined. The reason was that the authorities in US as well as in the European Union, they found this company is engaged in different activities which are against the allowed monopolization within the intellectual property framework. They violated some of the provisions of the competition law. So, they were heavily fined. But when we come to the India, the branch of the competition law itself is very new to the Indian authorities, and according to the TRIPS agreement, and we fully complied with the intellectual property law. So, we come out with a set of intellectual property legislations and then a new competition law. So, the jurisprudence is simply emerging. And the next part, I think probably is Nighari will explain to you in the second half about the Indian law in detail, and the last part of the jurisdiction different, we were discussing about a comparative jurisdiction of the US as well as the European Union. If you look into the United States, you can see that the antitrust law is considered as one of the very important magna carta of business, because this one of the country come out with a law on competition, promotes competition is the United States. The antitrust law is very strong in the United States, and that is considered to be one of there is a rich jurisprudence, the rich jurisprudence which is emerged for a period of more than century is the guiding principles to other countries as well. So, we discussed the pros and cons of the antitrust law from the very beginning, and also in the module we discussed almost all important cases with regard to competition law versus intellectual property law. And then we can see that then we are switch over to the European Union as well as the Indian competition law. So, this is the module which we, actually the entire course itself is modeled in such a way that the students of this particular course can understand the entire area of intellectual property and competition law, and whether they are really conflicting or supplementing. And we said many times that the competition law supplements the intellectual property law rather than conflicting with each other. And my colleague Niharya will explain to you the next of these modules which we are try to present before you. Yes,
thank
please.
you, sir. Hello all. So, after, as a brief introduction given by Professor Raju, like after going through the different fields of intellectual property law, so we are now in a position to understand that the aspects of competition law are not restricted to patent per se, it is applicable throughout all forms of the intellectual property law. And there are depending on the jurisdiction, like whether it is a US or European Union or India, the main motto of both IP and competition law remains the same, is to promote the innovation and promote a fair competition for the welfare of the society. So, having said these two aims of IP and as well as the competition law, in the Microsoft case, particularly the European Court of Justice has come out that in case of this European Union and particularly also in India, monopoly or dominance is per se is not bad, but however, abuse of dominance is considered to be anti-competitive in certain cases. But there it is said that like when there is a IP holder with in addition to this intellectual property, there comes the greater responsibility for the dominant player or the IP holder. And further, the case becomes much more complicated when this IP or maybe in the form of the patent or any other form of patent becomes a technological standard, which becomes the standard essential patent. So, the holder of the standard essential patent right has more what you say responsibility towards the society and towards the other probable licensees, like so that the development of the new products are not being stopped, or the consumer per se are getting all the benefits within a as required by the as explained in the principles of the competition law. So, if you look into the jurisprudence of the India has basically followed the competition law from the European jurisdiction. Earlier when there is MRTP Act, it is basically from the got inspired from the US Sermons Act or Clayton Act, where monopoly is like the act was basically to curb the monopoly, but when the Competition Act of 2002 came into practice, it is now more on the following the path of the European jurisprudence and law. And if you just compare the US, India or European Union, like in India as well as the European Union, it is like the European Commission on the Competition or the Indian CCI, like both are like administrative bodies which control the anti-competitive behavior of the various firms, whereas in the US both FTC, Federal Trade Commission as well as the Department of Justice, both of them take equal participation to determine the civil, the administrative as well as the criminal sanction on the things. So, but having said this, the main motto remains the same, like to promote competition, fair competition and fair like promote much more innovations. And in the European cases we have dealt European dealt with many cases starting from the like Microsoft, then starting from IMS and Magil, where like how the jurisprudence has defined like the exclusionary abuse or exploitative abuse has been taken into consideration, and even the latest judgment in the Huawei versus Jetty that taken account the both Samsung and the Motorola decisions, and where the means some way there is a responsibility from the patent holder not to grant injunction or not to think about injunction when there is a probable licensee who is willing to take your license under the FRAND terms, and as well as like it is not on the part of this licensee to say that the patents are not valid or he can invalidation claim can be made. So, as we saw through these cases, this jurisprudence is quite developing. Also in case of the India, the Micromax Ericsson case was the one of the landmark cases where not only the jurisprudential issue, like jurisdiction of the High Court or that has been challenged. So, these are like in the still in the developing phase, and with the upcoming ICT technologies and this telecom wars, like we are yet to see much more developments in this area. In particularly in the Indian system, since the European Union like there are case laws as well as the soft laws in the form of the guidelines. So, whereas the case laws is sometimes taken in the Commission's viewpoint as well as also taken into consideration to the soft laws, but in case of the India, our case laws are just being developed. So, much more developments are yet to be seen as the technology are developing. And in this course, we just wanted to give you a basic understanding of this IP and competition law, where like how these two fields of the study are complementary to each other. Like individually, we cannot IP holder per se cannot enjoy all the right when it is going against the principle of the competition law. We hope this course has been beneficial to you all, and thank you for giving us the thank you for watching us throughout this lecture series. And we will wait for your comments and valuable suggestions, and we would happy to share answer your queries if you have any. And
yeah, I think the students have already completed half of the courses, and the rest of the courses are going on, and we encourage all the students to read more on the issues. And so the one book is available which I have written some time back on IP and competition law, which you may read, and also the reading materials are also which we are uploaded. Please go through that. So the final question is not going to be too tough, and but definitely it is going to have you have to complete the courses, and we hope that this course is going to get each one of you. And when you will go ahead, and this is going to be an important area of the jurisprudence which is emerging between IP and competition law, and there is a new area of the course. As Nihari already said, that our objective is only to give us some basic idea on the interplay between intellectual property and competition law. So, we hope that this is going to be benefit to all the students, and so and also we hope that this is going to be an advanced stage in some time, and we wish all the participants of this course, all candidates of this course, all the best for your remaining modules and also for the exam. Yeah. So, thank you so very much.
All the best to you.
All the best to all of you.
Thank you.
Thank you.